Okay, now it's 11 a.m. here in Tokyo. Let's get started. Hello, everyone. Thank you for joining us today. I'm Yuki Onoe. I'm a chemical partner at Oblon. I'm with Derek Leitner today. He's also in a chemical group. We'll discuss the induced infringement and skinny labels today. The lecture is going to be about 40 minutes, 45 minutes. I will give you the introduction, few slides, and then Derek will discuss two cases, GSK versus Teva and Emerin versus Hikma. And I'll conclude the lecture. If you have any questions, there is a Q&A box you can type in, and we'll discuss at the end of the seminar. Right. Okay. Skinny labels. The skinny labels are the labels for the generic drugs. It's skinny because some information is missing from the label. The missing information is a patented indication. So when do we see it? We see those kind of labels when there's more than one indications in a brand name drug. And the way it works is generic firm can try to enter the market for only the known patented use. You can seek approval based on that. And we sometimes call that practice as an ANDA with a Section 8 carve-out based on the section that is irrelevant to that practice. Okay. So I said a patented indication. Of course, that comes from the patentee's method of use patent, and that is described to the FDA with the patent use code. Sometimes it's called just use code. In GSK's case that Derek is going to talk about, it was, I think, let's see. Code was the code was a U-233, decreasing mortality caused by congestive heart failure. So it's a code with a description, and that's something that a brand name company identifies and submits to the FDA. And the patent use code cannot be too broad, cannot be too narrow. You'll see that debate in GSK's case. And it must describe only the specific approved method of use claimed by the patent. That's the rule. So we'll discuss induced infringement. And the infringement, in this case, the potential or alleged inducer is a generic firm. So that in the case we were going to look at is not quite the regular ANDA situation where the infringement is a hypothetical infringement based on ANDA. But in GSK's case, Teva, a generic product, is in the market. It's after the launch. So the infringement is based on the use of the product, and the inducement here, the facts are kind of unique. But the court looked at what the generic firm said in press releases and other marketing materials. And one of the issues in the cases is that whether that could be a basis for inducement liability. Derek, did you discuss the GSK case?
Hello, everyone. Regarding the GSK case, GSK GlaxoSmithKline was producing and marketing under FDA approval the name brand heart medication Coreg Carvedilol, and ultimately, the questions that came up in this case were whether a competitor or a generic producer, an ANDA applicant like Teva, who uses a Section 8 carve-out but nonetheless makes marketing statements, implies use based on sales representations on discussing the name brand drug and discussing the pharmacological equivalence, which is actually necessary to get any new drug or ANDA application allowed. Whether they can nonetheless, despite using a Section 8 carve-out, can be found liable for induced infringement. Another issue in this sort of realm was whether an FDA-required generic label could be evidence of the intent to induce infringement, which to preempt any major concerns alone is not really possible, because the ANDA applicant is required to use the label that the FDA is basically a copy of the name brand label with this Section 8 carve-out, which is an exception to the exact identity, and an exception to the rule of exact identity. And finally, whether a patent holder, GSK, is stopped from asserting infringement on an indication it alleges to be infringed based upon its statements and use code submitted to the FDA. This is yet to be resolved, but based on the most recent Federal Court of Appeals for the Federal Circuit statements, it looks likely. So could we go to the next slide? I mentioned this a little bit before, jumped the gun. GSK was selling Coreg carvedilol, a beta blocker, initially under two use codes, under two FDA-approved uses, let's say, and ultimately they applied for and got a third use. The third use is, we've just labeled them 1, 2, and 3 for simplicity, and we're going to refer to them as, or I will refer to them as 1, 2, and 3. The patented use in contention, which was subject to the carve-out, is use 2, the congestive heart failure. As you see, use 3, left ventricular dysfunction following a myocardial infarction, a heart attack, is related to congestive heart failure. And then hypertension, which is also has a relationship to congestive heart failure. But each of these categories has separate evidentiary and submission requirements for the FDA to get each of the 3 uses approved. So there's discrete categories of submissions. GSK, and this is a very important point in the litigation, which is not yet resolved, but may be resolved in 2022 or 2023. They made a declaration to the FDA that only 2 was patent protected for Coreg after the expiration of the main compound patent. And as a bit of information for whoever is a pharmaceutical chemist, the use 3 is not simply the use of Coreg alone, the beta blocker. It was actually counterindicated for, they thought, for congestive heart failure, but it was used in combination with an ACE inhibitor and a diuretic, and I forget a fourth active ingredient. And over a certain period of time, I think it was 6 months, in order to get this evidentiary data to show that there was an effect of preventing left ventricular dysfunction after a heart attack. So actually, it's not stated on here, but Teva filed its initial ANDA in 2002. they have to notify, had to notify GSK of their allegation, of Teva's allegation that the patent was either unenforceable or invalid or etc. In order to submit the ANDA. And the submission of this paragraph 4 certification, i.e. that GSK's patents were not valid or enforceable regarding what had existed at the time of the ANDA filing, and this was a very complicated fact scenario, but GSK, normally a drug, a name brand drug manufacturer will sue. GSK did not do that. Instead, they reissued the then pending patent, or then existing patent, and it reissued as, initially it was the 069 patent, and it reissued as a 000, RE 40,000's reissue patent. And at that time, they delisted the 069 patent. GSK delisted it, but simultaneously or prior to delisting, or in an identical contemporaneously, listed the reissued 000 patent. So while this delisting occurred, the FDA requested that Teva amend their label to cover all of the uses in the name brand drug, but also requested that Teva submit their statement on the relevance of the 000 patent to what Teva was doing. Teva made the statement, which is likely incorrect, that because the reissue was granted after Teva's ANDA application was granted, it was not relevant. This is not, does not seem to be a correct statement. The reissue patent expired then after this period, 2011 to 2015, in which Teva was covering all uses, 1, 2, 3, despite the period in which they had a carve out from 2007 to 2011. Next slide. Took a little bit of time. Yuki? Yeah, okay. So Teva argued that they had properly followed a carve-out procedure under Hatch-Waxman and accurately described its skinny label product as AB generic equivalent. AB means that it's pharmacologically equivalent to the name brand already approved FDA drug. And Teva argued that GSK had failed to prove that Teva's labels and actions, including marketing information, press statements, etc., had encouraged direct infringement, because one needs direct infringement in order to have induced infringement. GSK argued that Teva's skinny label instructed and encouraged infringement, that all claim limitations were in 3 interrelated sections: indications, clinical studies, and dosage administration. Teva had marketing and sales statements, including the accumulated sales of all FDA-approved uses for which GSK was selling Coreg at the time. And Teva's marketing materials trumpeted, according to the statement of GSK, Teva's AB rating, i.e. its pharmacological equivalence, without expressly stating that the generic, the pharmacologically equivalent generic, was not approved in their statement, in their press statements for the congestive heart failure, which was an indisputably covered use during the time in which GSK had its skinny label and carved out. However, it didn't state that it was not FDA approved, that Teva did not state that Teva's generic was not FDA approved for use too. So next slide. In 2018, after a jury decided that Teva had indeed induced infringement of use 2 and 3, a district court judge in Delaware gave a judgment as a matter of law, JMOL, of non-infringement, which related to several things. One being that Teva is limited in how it can label its drugs based on FDA requirements. But also that being AB equivalent is required in order to get an ANDA approval. But even more significantly, I think, in that the necessary elements for inducing infringement were not established in the view of the judge. So, of course, the name brand appealed, GSK appealed to the Federal Circuit, and the CAFC panel reversed the JMOL, stating that there was ample evidence of causation to conduct the induced infringement or direct infringement based on promotional materials, press releases, product catalogs, FDA labels, and certain testimony. And the induced infringement allegedly was found for use 3. There was a big uproar at this initial decision, which I think was at March 2020. Let me look real quickly. In any event, it was in October 2020. And the Federal Circuit vacated the decision, even amongst this uproar, amongst, of course, the many generic manufacturers and even Waxman's office, the namesake of the legislation on this ANDA drug practice, FDA drug practice. The CAFC vacated its initial decision, particularly the parts in which it was implied that use of FDA labels alone, or not, they never really said alone, but there was a substantial relevance to correctly and properly using FDA labels. And they reissued a panel decision in August of 2021, again reaching the same conclusion, a 2-to-1 split, in which they made more clear that it wasn't simply the use of the generic skinny label, but in fact more that this alone would be insufficient. But the combination with Teva's marketing statements, press releases, and the like, the ancillary evidence, the evidence not directly about the FDA label, but more what they did, what information they provided to doctors, what information they provided to investors, and the like, on their website mainly, and in packaging material, or pamphlets for medical practitioners, that would render them subject to suit for induced infringement. And just recently, February 2022, the CAFC denied an en banc rehearing, meaning all, 11 justices would rehear, because it was a split panel, 2-to-1, each decision in 2020 and 2021. They decided the issues weren't significant enough regarding the labeling issues, and they found, in fact, that Teva's most important defense against the induced infringement finding on 3 would be based on equitable estoppel, which they would have to raise then again at the district court as an affirmative defense. Let's go to the next slide. And basically, I have to fill this in because it's not sufficiently written here that GSK had made representations to the FDA that its only covered use was 2. It was mentioned in a line in 2 slides previous, but this came up significantly in especially the denial of en banc rehearing at the Federal Circuit, that the statements that GSK, the name brand, had made to the FDA in declaration, as well as its patent use codes, were a basis for Teva to defend itself by potentially having infringed, having induced infringement, because they wanted to be able, or in general in the US courts of equity or British courts of equity, one can rely upon the statement of the right holder, the GSK, to an authority, to a right giver, the FDA, in order, they should be bound by those statements. And the FDA statements were sworn declarations, and so Teva theoretically should be able to rely upon GSK's statements to the FDA in knowing what it infringes and what it didn't. And GSK did not significantly enough apparently emphasize, this has not been finally resolved, but they did not significantly enough emphasize that use 3 was covered by patent. And then in the litigation, they did try to claim that Teva had infringed both under 2 and 3. So in sum, from the GSK progress to date, which is still unresolved, it'll go back to the district court, and then likely it will go back to the Federal Circuit. But it may be possible, even if a drug, a generic company uses a proper Section 8 carve-out for its ANDA approved non-infringing uses, carving out this still covered use, it is possible the patent holder can make a case for induced infringement. So a patent holder should look to press statements, investor statements, guidelines given to doctors, industry publications and the like, and a generic should on its side be very careful about what it does say to avoid rendering itself liable to induced infringement. And the inducement generally will need to, I don't know if it can be said for absolute certain, but it's quite certain, but it should come from evidence beyond the label, such as the marketing materials, press releases, and the like. And insofar as a generic company does not expressly state that their generic product is not suitable for use or is not approved for use in the still patented use 3 in this case, in the GSK case, they may render themselves liable to suit. So let's try the next slide. Excuse me. So in Amarin versus Hikma, it was a similar case in as far as Amarin and Hikma are concerned. Amarin is a name brand drug manufacturer. Hikma is generic. So the issue there was whether an ANDA applicant can be liable for induced infringement despite using a skinny label, properly using a skinny label. Again, and the new question was whether a health insurer in the US can be liable for induced infringement based upon its reimbursement rate and evaluation procedure for reimbursements. A sort of requisite to understand the health insurer potential liability here is that the US health system has what they call co-pays I guess we can go to the next slide, Yuki. A copay is a partial payment from a covered person, a health insurance covered person, for a part of the cost that the insurer covers the remainder of for any treatment. It could be going to the doctor and getting an x-ray taken. It could be a drug that you're taking, a prescription drug. It could be a medical procedure, etc. This is something that happens in the US, and all different health insurers have all different schemes for co-pays and reimbursements and the like. But this is a factor in this health net potential liability. Amarin owns the patents to Vasepta with 2 FDA-approved indications: severe hypertriglyceridemia, and number 1, and number 2 is cardiovascular risk reduction. Amarin, the name brand, gained approval for use 2 and modified its label to include indication 2. It previously had in its label an indication that use 2 was not FDA approved. In 2020, after this label modification, Hikma got FDA approval for its ANDA application, carving out under Section 8 use 2. Next slide, please. So until approval for use 2, the name brand label included this warning: the effect of Vasepta on cardiovascular mortality and morbidity in patients with severe hypertriglyceridemia has not been determined. Hikma's generic label, as in conformity with the law generally, had a carve-out, an exception, this Section 8 carve-out for use 2. As a consequence, the Hikma label, otherwise identical to the Amarin label, but having the carve-out of use 2, did not include the warning which was on the earlier Vasepta label. So Hikma marketed as generic, like in the case of Teva versus, or GSK Teva in Teva's case, with sales data and press statements, press releases, including Amarin's Vasepta uses, profits and sales for all patented uses. Now, allegedly, it's possible to parse out the profits for individual or sales for individual uses, but they did not do that. HealthNet, the health insurer that was sued alongside Hikma, required higher copays of Vasepta and a lower copay for the generic. This means, and it's actually quite common for this to occur in US health insurers, that because a name brand is generally a more expensive drug, the health insurer, who ultimately pays the cost of the drug, or the lion's share, the large majority of the cost, they will try to encourage, whenever possible, their covered persons to take the generic drug. And Amarin, quite cleverly, let's say, construed this as an inducement from HealthNet, the insurer, to health insurance for practitioners, doctors, and for patients to be encouraged to take the generic, to have the lower copay, to pay less. In addition to this, HealthNet had a prior authorization before payment for either the generic or the name brand. They had to submit paperwork and the authorization for which the drug was, the payment was being sought, the reimbursement for the cost of the medical, the pharmaceutical drug. Take a drink real quick. Excuse me. So this authorization was construed by Amarin to represent knowledge and intent of the healthcare insurer. The insurer, they would not only be providing lower prices, but also with knowledge of what the use was going to be. So let's go to the next slide. This is just an example of Hikma's press release, which the only relevant part to this infringement case was really, or evidentiary part. You can see in the second paragraph of it that it discusses the hypertriglyceridemia, and this was an allowed use, allowed statement of Hikma because it was already off patent. But the part of it below, the U.S. sales of Acepta were approximately $919 million in the 12 months ending February 2020. That included sales from both use 1 and the carved out use 2. Okay, there were a couple of these, but we just took an example. Can we go to the next slide, please? So the suit then took the case that developed in such a way that Ameren sued both Hikma, the generic manufacturer, and HealthNet, the insurer, for induced infringement. And in January 2020, because, and relying upon the GSK situation in which it was emphasized just prior in August of 2021 that just labeling alone is not sufficient to induce infringement, and in addition, it was stated, and it's actually precedent in the federal district, CAFC, that although a generic manufacturer has a duty not to promote infringement, it does not have an affirmative duty to prevent infringement. And the facts of the Hikma situation were such that it never made any statements regarding all of the uses. It only made its statements, as we saw on the slide before, about hypertriglyceridemia, which was off patent. The facts of the Hikma scenario were not sufficient in the view of the judge that in the federal district that Hikma be liable for induced infringement. However, the HealthNet motion to dismiss was denied because, and this suit has also not been finally resolved, but based upon its copay and evaluation protocol, which I dare say are not uncommon in the US. I don't know for certain, but it sounds very customary, to be honest. They denied HealthNet's motion to dismiss based on these assertions. So basically that there was a case. It was not that there is no case upon which a jury could find infringement. It's not been decided whether there's been infringement, but Hikma was dismissed from the litigation as having no facts upon which relief could be could be granted, and the HealthNet insurance company has been retained in the litigation. Let's go to the next slide. So in conclusion with this, which links a little bit to the GSK case, that the name brand company can look to a generic, and should look to generics marketing statements, press releases, statements to shareholders for the possibility of induced infringement, even if there's a Section 8 carve-out. So there is a case to be made, even for a properly labeled, properly carved out ANDA, that induced infringement is nonetheless present based upon statements to the public and shareholders and the like, and medical practitioners. But it's not certain that infringement will be found. It's just that you could be subject to suit, and with enough facts in the case of Teva, or in the case of HealthNet, a complaint with enough facts will survive an early motion to dismiss, which means a generic company could be subject, or a health insurance provider could be subject to a more expensive litigation than they hope if they're not careful with their wording on these statements and how they act. So let's go to the next slide. I think you're up, Yuki.
Yeah. So as Derek stated, the court could look at sales or marketing activities and to look for any inducement activities. So in GSK Teva case, what GSK did was to look at Teva's press releases and other materials, and that wasn't really limited to those were in public after the product launch. GSK looked at the press releases even at the time of the tentative approval of the ANDA. So if you're on the brand name side, you could look at what GSK did, look at the old statements, even the old labels, and then the case progresses. So, but the inducement is about the intent. So you can make an argument that the generic farm was always had this intent to encourage the infringing activities. If you're on the generic side, I guess what you could do is to look at the website of HICMA website that we looked at, just to say AB rated drug for the name brand, that seems to be okay. That's not really encouraging any patented indication. But if you had more than that, if your website says something that implies the use for the patented indication, that will be a red flag. If you're on the brand name side, look at all the materials, and even the small statement that it was like in Teva's case, it was Teva said generic version of GSK's cardiovascular agent Coreg. That little statement was used to implicate that that drug could be used for heart failure. So that was a whole statement, that was a whole situation. And if you're also on the brand name side, what you should do is to be careful on the statement to the FDA. We advise the brand name side clients that you should be careful in your statements to the patent offices, to the Japanese patent office and the USPTO and EPO. Everything needs to be coordinated. You can't be inconsistent. But something additional here is that you also need to be coordinated in terms of the statement to the FDA. In the GSK's case, what the issue was, the original patent use code that was narrower. That was the statement almost like my indication is just number 2. But later on, you kind of took the position that, well, it also covers number 3. So you want to be careful how you describe your invention to the PTO, to the patent offices. Also, you want to be careful in what you choose for the patent use code to the FDA, because they will, the generic farm, as Teva stated, that would be unfair if you make a narrower description to the FDA and then the generic farm relies on it. That is something that needs to be carved out. And then the patentee takes a broader position and says that we cover more than that. That will be viewed as a not so fair practice. So we'll see how it goes, but you want to maybe monitor the case, maybe look for, there could be other regulations about this practice. So to balance the both interests from the brand name side and then generic side. So you want to be careful about how it goes. All right. So I think we covered what we wanted to say. If you have any questions, you can type in now. You can also receive questions in email. You can also call me at the Tokyo office if you like to discuss in Japanese, perhaps. We'll be glad to follow up if you have any questions. Derek, do you have any final thoughts?
Yeah, basically these cases are still looking to be resolved in the coming months, and likely Obon will present further webinars or information about this, but you're welcome. I'm more of a prosecutor getting patents and doing some opinion work and supporting people. Yuki is a little bit of a all trades representative and is in Japan for us, but also comes back to the US. And our litigation department, who works day to day in this, will have likely more updates. Yuki is of course a part of the litigation department, and Akihiro in Japan. But we would welcome your questions, and anytime you looking for support in these matters, please feel free to contact us.
All right, thank you for joining us for the webinar. We look forward to meeting you in person in your future. Thank you very much.
Thank you. Bye-bye.